Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications. Exercise number 1 and 2 on the speed of 90 words per minute. Start. The main ground of challenge in the writ petition is that without determination of the actual market value of the land, the collector has proceeded merely on the basis of circle rate prevalent for residential plots and determined the deficiency in the stamp duty. According to the learned counsel for the petitioner, the said property, area of which is said to be 0.134 hectares, has been purchased to increase his holding, considering the fact that the adjoining land is that of the petitioner, where cultivation etc. is being done by the petitioner. It is also admitted that the said plot is a gaddha, that is, a ditch, and therefore cannot be used for agricultural purpose in its present state. The contention of the petitioner is that the plot in question is surrounded by agricultural property in which agricultural activities are going on and no abadi is there in the vicinity. However, one boundary wall of the roadway's stand is there, but that alone cannot be a determinative factor for treating the property to be residential. Further contention of the learned counsel for the petitioner is that the collector has relied upon a report dated 24/3/2007, which is said to be of prior to initiation of the proceeding under section 47A(3) of the Act, and therefore the Commissioner erred in law in relying upon the same. Further contention is that subsequent spot inspection report submitted by the sub-registrar dated 24/1/2008 clearly mentions that the property is agricultural, and therefore the order of the collector treating the property to be residential cannot be sustained, as the same has been held to be so without any basis. The matter was carried to the Commissioner, but the Commissioner also affirmed the order of the collector without interfering with the same. The point for consideration before this court is that the property in question, which is held by the collector to be of residential potentiality, is on the basis of report dated 24/3/2007, but the subsequent report of the sub-registrar dated 24/1/2008 has given a finding that the property in question is agricultural. I have heard Sri Pradeep Kumar Rai, learned counsel for the petitioner, and the learned standing counsel appearing for the state. In my view, the provisions of section 47A(3) of the Act clearly mandates that either suo motu or upon some report of any other authority proceeding can be initiated, and the collector, after issuing notice to the petitioner can proceed to determine the market value of the property in question for determination of deficiency in the leviable stamp duty. This court in the case of Ram Khelawan at the rate Bachcha versus State of Uttar Pradesh reported in 2005 98 RD 511 has clearly held that for the purpose of determination of market value, same principle has to be adopted as for determination of payment of compensation to the landholders under the land acquisition proceedings. It is wholly irrelevant whether the said property has been recorded as agricultural in the revenue records or not. The writ petitioners before us as appellants have been selected in the written and oral examinations under the dying in harness category, but they failed in the test of physical fitness. According to them, due to shortage of time, that is 10 days between the other examinations and the physical fitness test, they were not prepared for such physical fitness test. Therefore, they are entitled for the second opportunity if the relevant rules, government orders and the order of the division bench dated 20th December 2006 passed in special appeal number 1602 of 2006 are taken together. Learned single judge in his order dated 16/2/2010 has held that no right can be vested with the candidates to become successful in the examinations under the category of dying in harness along with others who get appointment with the confirmation of a status and reservation of the post. Time always vitiates the need of compassionate appointment, and in the present case, no financial hardship is supposed to be faced by the family, and at least the same can be reflected when they are also fighting for cause for the last 4 years. Mr. C.B. Yadav, learned senior counsel appearing for the appellants, has contended before us that the appellants before this court cannot be discriminated with others who have already been given an opportunity. Moreover, we have to go by the import of the order of the division bench in Pankaj Kumar Vishnoi Supra with reference to the rule, if any, when the reason has been shown therein with regard to the dependent of the deceased employee, that after a period of 4 years, whether he became unfit or more fit, it necessitates for consideration. We further find from the order of the learned single judge in Srimati Neelam Verma Supra, as referred, that in the said case, the selection under the dying in harness category was preceded on the basis of an application of the petitioner, therein dated 24th May 2001, wherein she failed, and thereafter on the basis of her letter dated 3rd July 2009, she sought another opportunity which was declined by the authority concerned. In this background, the order was passed therein. Therefore, the cause was considered by the self-same learned single judge after a period of 8 years from the date of original application for appointment on compassionate ground. Hence, without apprising all these facts, we cannot hold and say whether at this belated stage such order can be passed on account of compassionate appointment or not. Before going into such controversy, we should say that giving or not giving the compassionate appointment in the cases not backed by any rule is different from the cases which are backed by any rule. The question of breadwinning of the dependent will be considered at the threshold, but when the ball has been rolled by allowing the appellants to sit for the written and oral examinations and they have become successful, we cannot put the clock backwards without affording any equitable justice.